Welcome to today's edition of Florida Appeals Journal. I'm Jennifer Carroll, and today let's talk about everybody's favorite subject, summary judgment. There can be no question that summary judgment is and has been for a long time, and is becoming more so, uh, the focus of modern litigation in both state and federal courts. And everyone knows, and we addressed this in another video, that Florida in recent times has now adopted the federal summary judgment standard. What does that mean? Most attorneys, and of course most lay people, most clients, are very confused on the summary judgment standard. What does it mean? All right, so today I put together just a brief summary. I think of some pretty good case law out of the federal court that really explains and will help you in navigating through the summary judgment standard. Now, everyone's familiar with the so-called trilogy of U.S. Supreme Court cases. That's the Celotex Corp case, the Anderson v. Liberty Lobby, and the Matsushita Electric case versus Zenith Radio. And I think that was back in '86. And the Supreme Court was laying out standards for summary judgment. Uh, and you've got various courts interpreting that standard in so many ways. Typically, the federal standard has been interpreted as giving much more deference and discretion to a trial judge when evaluating the record and when determining if a litigant is entitled to judgment as a matter of law. That's been the general feel. Yet, and that's why people would choose, they're going to bring a case in federal when you're apt to get out on summary judgment, or you're going to stay in state court and maybe have a better chance of going to a jury trial. But of course, that doesn't exist anymore. Now, Florida, I'm talking about Florida, and many states are in line with the federal summary judgment standard. So that's why I think it's good to go by what the federal law has become in the case law. So there's a case in particular that came out in 2014. And believe it or not, the U.S. Supreme Court, and as you know, in 2010, I think there were some amendments in the federal summary judgment rule. But in 2014, there was a really good case that came out of the United States Supreme Court, and believe it or not, that addressed the summary judgment standard. So I want us to look at that because I think that gives a really good analysis and a good summary for how summary judgment should be applied. And I just want to say, I think what happens all too often, and this is what people always get worried about, and I guess it's always been the controversy with summary judgment, is at what point does the trial judge cross the line and become a seventh juror and is really weighing the evidence and making a determination that really is a determination to be made by the jury? And how do you define that line? How do you define the parameters of that? And of course, we don't want to speculate. We got to go by case law. So there's a very good case that came out. And by the way, and you don't want to you don't want to cross that line, whether you're a litigant or a trial judge. You don't want to cross that line. You can invade the litigant's constitutional right to a jury trial. We don't want to do that. Okay. So I'm going to refer you to a case, Tolan v. Cotton, Tolan versus Cotton, 572 U.S. 650, 656 to 57. And that's a 2014 case. In that case, the U.S. Supreme Court articulated the federal summary judgment standard. Quote, a judge's function at summary judgment is not, quote, to weigh the evidence and determine the truth of the matter, but to determine whether there is a genuine issue for trial. Pretty standard language. I think everybody knows that, but of course, implementing it is always the challenge, and how it's implemented in a particular case. But continuing, so the court cited, of course, Sanderson. Quote, summary judgment is appropriate only if the movement shows that there is no genuine issue as to any material fact, and the movement is entitled to judgment as a matter of law. And they cite Federal Rule of Civil Procedure 56A. In making that determination, a court must view the evidence in the light most favorable to the opposing party. Now, the court continues. In the analogous context of summary judgment under Rule 56, we have stated that the court must review the record taken as a whole, citing Matsushita. And the standard for granting summary judgment mirrors the standard for judgment as a matter of law, such that, quote, the inquiry under each is the same. It therefore follows that in entertaining a motion for judgment as a matter of law, the court should review all of the evidence in the record. This is something to be aware of, you can be sensitive to, because that doesn't always happen. So you want to be alert to that and make sure that is going on. You've got all the evidence in the record. It is being reviewed by the court. Continuing. In doing so, however, the court, again, must draw all reasonable inferences in favor of the non-moving party, and it may not make credibility determinations or weigh the evidence. Credibility determinations, the weighing of the evidence, and the drawing of legitimate inferences from the facts are jury functions, not those of a judge, citing Liberty Lobby. Thus, although the court should review the record as a whole, it must disregard all evidence favorable to the moving party that the jury is not required to believe. And that refer you to Reeves v. Sanderson Plumbing Products, 530 U.S. 133, 150 to 151. Now, in the case that I was citing to you, and that's in the Tolan case, what's very interesting in that case is the court held that, and they were dealing with the Fifth District, or the Fifth Circuit Court of Appeals. They held that the Fifth District Court of Appeals had interpreted and applied the federal summary judgment standard as a seventh juror. It's an unusual case because you don't often see that. Usually, summary judgment. How are you going to take a summary judgment case to the U.S. Supreme Court? Because lip service is always going to be paid to these basic standards. Is there a genuine issue of material fact? You have to draw inferences in favor, all reasonable inferences in favor of the non-moving party. But the court actually took this case on in the Tolan v. Cotton case, and they specifically ruled, quote, the Fifth Circuit failed to view the evidence at summary judgment in the light most favorable to Tolan with respect to the central facts of the case. The U.S. Supreme Court actually conducted that analysis, as stated by this court in Tolan. By failing to credit evidence that contradicted some of its key factual conclusions, the court improperly, quote, weighed the evidence and resolved disputed issues in favor of the moving party. Again, Tolan continues to state, considered together, these facts lead to the inescapable conclusion that the court below credited the evidence of the party seeking summary judgment and failed properly to acknowledge key evidence offered by the party opposing that motion. And while this court is not equipped to correct every perceived error coming from the lower federal courts, we know this very well, we intervene here because the opinion below reflects a clear misapprehension of summary judgment standards in light of our precedents. A fascinating decision that here at the U.S. Supreme Court thought it significant enough to address and to spell out in a detailed opinion. And yet, summary judgment, the application of the standard, continues to be an issue, right? It continues to be a controversy. It's a good way to get rid of basis. I mean, some would argue, and you don't want to believe that, um, but some would argue that. And so that's why an understanding of the standard to be applied, how it's to be implemented, how it's to be applied is really critical. And not just we want to protect the constitutional rights of the litigant and for the day in court, if that litigant, of course, has evidence that it's sufficient to get to the jury. But you got to know how to apply it. What are the rules? What are the standards to follow? And I would recommend looking at the Tolan v. Cotton case. It's an excellent case that lays that out. Now, that was in 2014. And I think we still have issues coming up, and the Supreme Court deems these procedural rules, which, of course, were created by the U.S. Supreme Court, and they have authority over them. And so they need to make sure, the court needs to make sure that the rules are being uh, implemented, hopefully in a uniform fashion throughout the country. Uh, any questions, as usual, let us know, and thank you for attending. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.